trying to keep him from. We'll talk about that later too. We're supposed to be in London right now.
He is, or you are?
I am.
London, England?
Yeah. Yes, London, England.
Why?
Bachelor party.
Oh, jeez. Tough life you live, you know?
I'm not there, so it is tough. It's tough. I'll recover, maybe. It's one of my really, one of my best friends in the world. So.
Wow. Well, good morning, everybody. Welcome back to Law and Legitimacy. It's Wednesday, I think, middle of a tough week, at least for me. We are going back to court today. The jury got the case yesterday. Case of State of Connecticut versus Leon Guerrera, charged with murder. His defense is self-defense. It was a street brawl between a number of people. A bystander was shot, not one of the participants in the brawl. And it raises an interesting legal issue of so-called transferred intent. If I aim a gun at you intending to kill you, but I miss and shoot somebody else, my intent.
That's fine. It's okay. It's fine.
It's transferred to the other person. We argued self-defense, and it was, a very complicated fact pattern. The jury has had the case for an afternoon. They will resume deliberations this morning. The jury is being asked to consider a number of what are called lesser included offenses. Murder is one form of unlawfully taking the life of another. There are various forms of manslaughter and something called criminally negligent homicide. The jury will have to decide whether, in fact, our client was not justified in shooting. In other words, whether there was no valid self-defense claim. And if there was not, then it'll have to decide whether he killed with an intent to kill, out of extreme indifference to human life, out of perceiving an unjustifiable risk that someone would come to serious injury and acting anyhow, or failing to perceive the risk at all, those being the four different mental states that attend to each of those offenses. So if you see me a little bit on pins and needles and sense that there's a pit in my stomach, there is today, because one of the hardest things to do in the life of a criminal defense lawyer is to await a verdict with a person that you care about and that you think is a good man who was involved in a horrible situation. He may have made a mistake. Those of you who have a permit to use a gun, as this man did, understand that using it is always going to put you in the middle of a very complicated legal thicket where the stakes could not be higher. Should our client be convicted of murder, he faces up to 65 years in prison, given Connecticut sentencing laws. Should he be convicted of manslaughter in the first, 45 years, manslaughter in the second, 25 years, criminally negligent homicide, 1. So, he and his family have a tense wait. We have a tense wait. My gut tells me we'll get a verdict today. So,
well, what's interesting about that, Norm, I've had, because I'm in the ABC world, we have here in North Carolina what's known as ALE, Alcohol Law Enforcement, and they're essentially like the state level ATF, right? They handle, drugs, firearms, racketeering, obviously alcohol stuff. And they're sort of, as a law enforcement, sort of real world force in concert with the ABC laws, create weird burdens. I say weird, but just additional burdens on licensees, permittees in the beverage alcohol world. And as of late, I've had clients, here and there coming to me asking about what their policies should be about, concealed carry or lawful carry inside of their establishments. And even have had clients ask about whether there should be a policy of allowing employees to do so. And the interesting thing, Norm, is that it gets back to, there's a technical legal answer to all of that stuff, right?
Yeah.
But is that really what the question is? It's sort of, is the answer to the question the technical law and or laws or regulations and or regulations? To me, the answer is probably not what is technically lawful, especially in when you're bringing people together for ostensibly for commerce. And what you can't control for are people's competence levels with firearms, how they handle escalating tensions, and interpersonal dynamics that become hostile or adverse, especially in and around, the consumption of alcohol. So what I
Yeah, I
always
mean,
say,
I'm thinking a bar and a gun sounds like a recipe for
yeah, so
disaster.
I always, I don't, you know, revel in getting asked the question, but it is an opportunity to have a very, intimate conversation with the client, to have them kind of think practically about the question that they're asking, and what the
Does North
answer.
Carolina permit a permittee to bar a person from bringing a gun into their establishment?
Sure, yeah, yeah, as an establishment, you may bar, firearms on your private
What
property.
if I were I a bar owner, and I what would your advice be to me? I mean, I would be inclined to tell people just don't let people bring guns in if they're drinking, because if they're drinking,
Well,
sometimes they're
yeah,
not drinking.
yeah, I mean, from a legal perspective, if, there's North Carolina has, concealed carry laws and there's open carry laws. And, technically, if you're in an establishment, you're not supposed to be drinking and carrying, right? Those 2 things, legally are pretty mutually exclusive. And I think they should be from
You're
a
hedging. They either are or they I don't mean to be rude, but when you say pretty mutually exclusive,
well,
can
I
you have
say
one
I am hedging
go
because you don't always know when somebody's carrying a firearm. So, my
mhm,
advice to you as a client is, if there's somebody who is open carrying in your establishment and you don't have a policy that says that they're not allowed to bring firearms onto the property, then your obligation is to ensure that they're not consuming alcohol,
mhm,
or they go put that firearm in a safe, secure location and come back without it, right? Uh,
mhm,
so that's where there's black and white. But as I said, as a permittee, as an invitor, right? From a premises liability perspective, it's nearly unknowable to know who is carrying concealed on your premises.
yeah,
And to that end, it's an uncertain situation. But when it comes to whether bartenders or a manager should be carrying, these are all really interesting questions. And again, just to kind of carve our path back to reality here with what you're dealing with your client, um, it's not unreasonable to think that somebody could be having to have attempted to do something in good faith or come to the defense of others, but still been negligent in so doing, right?
mhm.
Um, and that is the essence of what the answer kind of comes down to with clients in my realm, is that you are inviting you're already skipping to the end where you're thinking about the discharge of a firearm on your premises. How does that make you feel?
Yeah, no, I hear you. I wish, I wish my wish for the public at large is that they had more of an opportunity to view actual trials and to see just how difficult it is to sort out an ordinary sort of conflict. And I'm not calling the shooting death of another human being an ordinary conflict, but I am calling it something that occurred within a few seconds. And, there were various videotapes from various angles, various backstories based on the participants, various disputes about who said what to whom and when. And then there is the letter of the law as applied to these facts. And I'll tell you, Mike, this jury could do just about anything with this case. And sitting next to a guy who with a loving family who turns up to court every day and a loving daughter who will lose his care and custody should he be incarcerated is a special form of hell. And it's been a very bitter trial. I've been threatened from the gallery, which happens from time to time by the family of the decedent, and one of them had to be removed from the courtroom and barred from the courtroom. We had a meeting in chambers. I said, Judge, I really don't care to try the case under circumstances of being personally threatened. He says, well, I can't say I blame you. What do you want me to do about it? Do you want a metal detector outside the courtroom door? And I said, no, not really. There's already one downstairs. I mean, what good is that going to do? So, guns, death, and in your case, Mike, guns, death, and bars, combustible combination.
Well, and
Clearly,
it should be no secret to our viewers that I am, an advocate of the Second Amendment, and I grew up in an environment that afforded me a healthy respect and also competence for firearms and the standards, that individuals should be held to and should hold themselves to and hold others to.
yeah,
But
yeah,
that comes into direct conflict when I'm thinking about the interests of the client, right? The best interests of the client are the business. And so then there are the individual components of the business that are the employees and the patrons, the vendors, all of these various confluences that intersect in these environments. And human behavior is nothing if not unpredictable, like predictably unpredictable, right?
Not the case.
Um, and so I'm moved by the situation that you have with your client, just because God forbid, anything attend to any of my clients in that way, where they're dealing with that from a premises liability perspective, from a criminal perspective, and from a civil perspective, because there's always that coming down the pike as well, right?
From a human level, it's impossible to sit in a courtroom and say, "But for the grace of God, there go I." Life is difficult.
Quick,
But
rare repose here for us. Comedic moment for Mari. The dog in the picture there, we're learning, is Mari Popovich, which, which it was spawned by Daisy Girl saying, "Good morning, Mari. Your name always makes me think you are not the father." And then we've got Mari Popovich. That's great, man. That's great.
I
Always.
liked it. So
Anyway,
Todd Blanche has written a letter to Judge Mershon. You sent it over to me this morning, Mike. My screen wasn't able to resolve it, but I gather he's calling for Judge Mershon to do the right thing, and to revoke the gag order that's in place.
yeah, if you don't
Right
mind,
to the
I'll try to
trial.
pull it up on my phone. I did try to open it up. I had to really, again, here's an opportunity for me to soapbox stuff from the media. Everybody, this is the AP. The article on the screen right now is from the AP. You sent me one from CNN, Norm. I saw stuff from the Washington Post, from I believe Forbes, maybe, or Bloomberg. The common feature of all of those stories, they're reporting on a letter that none of them directly reference. Inside of they'll quote pieces of it, but they won't hyperlink. They won't include an image. It's baffling to me how you could be reporting on something that exists, but not actually contain it in the story for just to give dignity to your viewers to read it for themselves. Anyway, I went the extra mile, and guess where I found it? On X. Shout out to Elon. Um, and if you give me just a second here, Norm, I'll pull it up.
So
It's
a gag order, as people know, is an order
Yeah.
from a court to a trial participant not to speak. And in the Trump case, Judge Mershon directed Donald Trump, the defendant in this case, the person who didn't ask to be in court, who's not a licensed member of the bar, and ordered him not to speak about certain witnesses, the judge, his family, the jurors, and so forth. And, the Donald challenge that was held in contempt a number of times, I think 10 times, and fined the statutory maximum each time of $10,000. The trial is now over. And the customary justification for having a gag order is to assure the fairness of the proceedings. And those who are affected most by adverse trial publicity are jurors. And so once the juror's gone, the justification for a prior restraint on speech, for a gag order, in my view, disappears. And I'm hard pressed to think of any legal justification for Mershon continuing with the gag order. What does Blanche say in his letter?
Yeah, I mean, you've essentially nailed it. So this is dated June 3rd. The letterhead is from Blanche Law. So this is his firm, and it's to the Honorable Juan M. Mershon, People v. Trump. Dear Justice Mershon, we respectfully submit this pre-motion letter requesting Your Honor terminate the gag order restricting President Trump's extrajudicial statements for the reasons set forth below, because the trial has concluded the stated basis for the gag order no longer exists. Unless the court grants the requested relief based on this letter and any response from the government, we further request an opportunity to submit briefing on this issue. The proffered justifications for the gag order, which we disagree with, related to the trial. The government's February 22nd, 2024 motion stated that the prosecution was seeking to, quote, protect the integrity of this criminal proceeding and avoid prejudice to the jury, end quote. In the March 2024 order, the court reasoned that, quote, the eve of trial is upon us, end quote. On March 29th, 2024, the government filed a letter seeking expansion of the gag order based on concerns relating to, quote, trial participants, end quote, trial witnesses, and, quote, prospective jurors, end quote. In the April 2024 order, the court referred to concerns about, quote, a juror, a witness, and personnel participating in the trial, quote, in some other capacity. Now that the trial is concluded, the concerns articulated by the government, and the court do not justify continued restrictions on the First Amendment rights of President Trump, who remains the leading candidate in the 2024 presidential election and the American people. The constitutional mandate for unrestrained campaign advocacy by President Trump is even stronger in light of one, President Biden's May 28th campaign event outside the courthouse during the defense summation, two, President Biden's public comments regarding the jury's verdict on May 31st, three, continued public attacks against President Trump by government witnesses Michael Cohen and Stormy Daniels, and four, the presidential debate scheduled for June 27th, 2024. And it goes on. It's essentially that's the end. It's a lot of citations to various cases and prior testimony.
Well,
So
it seems to me that he's dead right. I don't know, I mean,
I don't know
so
what there is to argue with, and in particular, I mean, we all had to suffer through the embarrassment that was what's his name outside the courthouse, the actor Robert De Niro. Good God, man!
my look-alike, I'm told,
Goodness
yeah.
gracious, man. That was just like, ugh, geez. But I think most importantly, Biden has answered the call given by Trump to debate, and that is to me the most pressing issue related to this gag order is that if they are to debate, which we've been, as an American public and an American citizenry, a voting public, we've been deprived of this for quite a long time, right? The two leading candidates, one is now the incumbent in a head-to-head debate. I think we got it once during the 2020 cycle. Does anybody remember if it was any more than that?
I don't.
Regardless, this is really important right now. The fact that they have agreed to debate, regardless of the constraints and any of the additional and whether it actually happens, that it is scheduled right now tentatively for June 27th. To me,
Well,
Norm, that would be
yeah.
the overwhelming justification for removing the gap in light of the fact that we already have a conviction. The trial's over.
Yeah, I hear you on the debate thing. I'm less interested in the election than I am in the First Amendment principles and the notion that the government, in the form of the court, can justify, the limited justifications for a prior restraint on speech. Prior restraints are anathema in American law. They always have been. They should be doubly so with respect to a presidential candidate. So we are calling on Judge Merchan to sua sponte, that is, on his own initiative, vacate the gag order forthwith.
Sue who? Who are we saying he needs to sue?
SUA, new word, SPONT, sua sponte. That's the legal word of the day. So let's see what happens in that case. I hope it doesn't have to go to full briefing. That would
Hey, if you're here, make sure that you are subscribed and that you have liked this stream. I usually wait until the very end, Norm, but I think it may be worthwhile to just remind people, hey, if you're here, hit the like button, hit the thumbs up. Helps us a lot with traction and revenue and all sorts of small things that we are hoping to make bigger over time.
Yeah,
So
in particular, the revenue. Hey, shocking case in Vermont. Apparently Vermont has a foster care crisis. Children from broken homes or whose parents had abandoned them or abused them and have been placed in state custody, need to be cared for, obviously. And a family is preferable to an institutional arrangement. And so Vermont solicits families to open their homes and to share the love they have with these little creatures so desperately in need of love. Brian Wooty, I'm not sure I'm pronouncing it correctly.
I could
Uoti, and his wife Katie, and Brian Grant and his wife Rebecca have opened their homes over the years and have adopted 5 foster children. They've said, we'll not only provide temporary care and support for these kids, we will make them a permanent part of our families, sort of the ultimate expression of love. Those of you who have raised children sired by another know what it is to take in a stranger, as it were, and cloak him in the love of that you have for your other children. I've raised 3 kids, one from my wife's first marriage, and I call him my own. We've been together since he was 8, and my regard for him is indistinguishable from my regard for the children that I had with my first wife. And so, it's a good thing. So Vermont, however, has taken some sort of step to require that those who take foster children subscribe to what I'll call sort of woke requirements. Basically, that you have to use certain pronouns in your home.
Well,
That
and under I think the broadly, this suit alleges that under Vermont's current policy, that the foster care department can actually, decline an application and deem an applicant unfit based solely on the applicant's religious views.
Yeah, that can't be right under the First Amendment. And, it expresses itself with regard to whether these families were willing to encourage children to engage in gender transitions, which in the Wooty and Grant cases were against their religious convictions. So they have been deprived of, I guess, the right to apply to become foster parents on account of their religious views. And that strikes me to be a direct hit on the First Amendment's ban against the state's establishment of religion. And it's, the case is pending in the Vermont federal courts. That the good news is it'll end up in the Second Circuit, which is a very sophisticated federal appellate court. And I think from there, this is a case to watch. This could go all the way to the United States Supreme Court.
I'm interested in tracking this. And well, let me not bury the lead. It's not necessarily the lead, but we're making it the lead today. Shout out to the New York Sun for hyperlinking the actual complaint in their article. Bravo. Thank you for doing
They're
us.
following your lead, Mike. And the author is MJ Koch, Koch. She's a new Harvard graduate, another knockout performer at the New York Sun, which is becoming a go-to source of news for both of us.
The plaintiffs in this case, Norm, you talked about Brian and Caitlin. There's also, I think, a pastor, Michael Gant, and his wife Rebecca. But the article in New York Sun actually reports the fact that these couples together have adopted, I think, 5 or more children over the last 10 years, including some with special needs. So they're not new to the party, quote unquote, with respect to applying for a foster care status for children. Right? They're actually complainants that have a history of successfully fostering children into adulthood.
Yeah. Let's see what happens. I mean, I think it's a flat out violation of the First Amendment. It seems to me the opt out is simple. If the family does not want to take a child that wants to transition, then send that child to another home. I think the awkward policy consideration would be, what if they take a child and that child then decides they want to transition? What then? And what is in the child's welfare? That raises a whole different set of public policy considerations. I mean, from the Wooties and Grant's perspective, I suspect the Bible speaks, and it speaks of only 2 genders, and God creates you at the moment of creation, and you are what you are.
Well, at the heart of what it means to be a foster parent. I think that many people sort of just overlook the essence of parenthood. I certainly don't anymore. I may have several years ago, but it's a unique relationship. It's a unique bond, and it's also a tremendous responsibility. And so, for people who are willing to take on that responsibility during the formative years for young people and give them the stability of a home, uh, you know, meals and what they need in terms of love and affection, and teach them things. Why would we draw a line around the morals that guided those people to be so giving and benevolent, right?
I don't know. Well, I mean, maybe, the religion, my wife and I are engaged in an interesting project. We've decided to watch the best legal movies, and so we got a list of them. And on that list was not the one we started with and that we're just about done with right now, which is Inherit the Wind, the story of the Scopes monkey trial with
Oh, wow, I didn't know they made a movie about that.
Oh
Wow.
yeah, it's a 1960 performance, and Spencer Tracy plays Clarence Darrow. They've renamed everyone, and I can't remember the name of the actor who plays William Jennings Bryant, but it's a really stark portrayal of what was at stake in the trial. In Dayton, Ohio, which I believe is the town they rename it Hillsborough in Inherit the Wind. It was, give me that old time religion. And the Bible was the word of God, and every word in it was inerrant. And Tennessee had a law that prohibited the teaching of evolution. So a young teacher named Scopes was sought by a public interest group. He taught evolution. He was charged, and Clarence Darrow was brought in by the Baltimore Sun. And in I can't recall who portrays H.L. Mencken, the old newspaper columnist, sardonic wit. But you know, there are moments in the film where Mencken expresses his great cynicism about the morals and ethics of ordinary people. Darrow's there to defend not just Scopes, but the principle of intellectual independence. And William Jennings Bryan, who had run for president a number of times, was brought in for the prosecution as a special prosecutor. So it was one of those trials of the century that really was the trial of the century. And in it, you know, it's a television trial, and so the lawyers get into colloquies with one another, which advance the script but don't shed any light really on the legal proceedings. But I recommend that all of you watch the movie to help understand a little bit about what's going on in the Vermont foster care families case, because you get the impression that Brian Wooty and Brian Grant and their families believe in that old time religion, that the Bible is the word of God and every word in it is inerrant, and it's man's obligation to live a godly life according to the Bible, notwithstanding what the state says.
This
Now,
is one of the best book recommendations I've been given in the last 5 or 6 years. No offense, Norman, you didn't give it to me, but Summer for the Gods is a tremendous. It's a Pulitzer Prize winner. Ed Larson is the author, and it also covers it. So I think now I need to go watch the movie. But for those of us who have not read this book, this is a great grab. Really,
yeah, Eric Larson's a fantastic author. I think he's written period pieces about the Chicago World's Fair in the 1890s, and he's a wonderful writer, and it is a fantastic book. And those of you who care about the intersection of religion and politics and how the courts sort them out owe yourself this book. You know, Darrow was one of the greatest lawyers in American history. He lost the trial, but he humiliated William Jennings Bryan because Darrow brought in a series of academic experts on evolution to prove that it was, you know, not hocus pocus. And the court held that because the standard that was being tested was whether Scopes broke Tennessee law by teaching something that the law prohibited, to it evolution, the testimony of the experts was irrelevant. And so he wouldn't let Darrow put on his experts. So instead, Darrow sarcastically asked, well, would the court, because this is about what the Bible requires, would the court consider a Bible expert? And the judge, you know, well, looks at him and, what do you say, state? Sure. So he calls William Jennings Bryan, his adversary, to the stand, something that you'd never see. Usually you can't participate as a witness if you're an advocate, but Bryant rather consents to being examined and is ridiculed by Darrow in the course of the trial. And there's a very touching scene in the movie where Bryant says to his wife, Bay, his wife of 40 years, you know, they laughed at me, and she consoles her husband, who is now a broken man and shortly thereafter dies. But the point of the movie was Darrow won the battle of public opinion. Tennessee won the fight because it did break the law, and the law was ultimately changed. So take a look at it here at the Wind. Here, yeah, these are scenes from it. This is I think the man was named Cates. That's Scopes there, and he's teaching evolution and then is shortly thereafter arrested and put on trial. So the Scopes Monkey trial is one of American history's great trials. And the reason I'm bringing you this, and will bring you quick reviews of other movies, is I'm so concerned with how we are portraying what goes on in courtrooms right now, apropos Trump and Biden's son, and the hyperbolic criticisms that's going on in the Judiciary Committee, that I'd like to give us another perspective on. I think we're using trials to dramatize underlying realities in ways that disserve the court, in ways that disserve our sense of justice. And on that note, there were fireworks yesterday in the Judiciary Committee. Merrick Garland was called in, and he was asked. There's a contempt citation being pressed against him for not providing Congress, a Congressional Oversight Committee, with a video or an audio tape, rather, of an interview with President Biden and Special Counsel Hur over Biden's apparent use and retention of national security documents when he was out of the White House, or his misuse of those documents, paralleling sort of the interest that the federal government has in Trump. And on display in the Judiciary Committee just was that sort of partisan rancor that, to my mind, is the despair of the country. I am not a Merrick Garland fan. I think his treatment of the January 6th defendants is sufficient reason to vote him out of office. I don't know that I could hold him in contempt for it. But fireworks were on display in the Judiciary Committee yesterday.
Yeah, and the Wall Street Journal also reports in this article that Biden actually asserted executive privilege over these audio recordings, I think last month. So
Mm.
there's multiple layers to this, but I think we have, just to be fair to our viewers, we have been harshly critical of Attorney General Merrick Garland over the last, I would say, probably 2 years at the very least, but principally, Norm, based on the Department of Justice treatment of the January 6th prosecutions in
Mm.
DC, and the continued aggressive tactics toward prosecuting anyone who seems to have been within spitting distance thereof, and sort of the taint and the stain on the Department of Justice reputation as a result. One of the most meaningful comparisons that you've made to me, in my opinion, Norm, is the contrast between how we treated uh, what was at that point the defeated um, uh, Southern Army after the Civil War, right? And the timeline attendant there too, and the way that January 6th protesters are being treated and prosecuted by the current Department of Justice.
So I begin to get a window into what the DOJ is up to, though, by a story that I read in the New York Times over the weekend. The Times is apparently tracking the number of occasions on which Trump is calling into question preemptively the results of the 2024 election. And apparently he does so at least once a day. Over the course of a year, they found some 560 or so utterances from Trump, either on Twitter or in public, where he talked about corrupt elections, fake elections, this, that, the other thing. And so I think what the DOJ is doing is putting a hard line out there saying, look, 2020 was bad. 2021 was worse. We expect more of this to come this year, and beware, beware, beware.
Yeah.
Not sure. I'm not sure what to make of that message. I'm not
Just
sure.
to acknowledge Jackson Barrett over on the Green platform, he says Kabuki theater, professional wrestling, quote, hearings. I really can't agree more, and I think that I've probably said something to that same effect, Norm. It's been some time since we've talked about Jim Jordan and sort of the Congressional Oversight Committee and the House Intelligence Committee and all these things, but I think, particularly because Dr. Fauci is in the news again this week, related to his handling of funding related to uh, the um, uh, the lab leak theory related to the coronavirus, and then even with the Hunter Biden, I think I read yesterday where the laptop has been submitted as evidence by the state in that trial, and you know, color me shocked that 51 intelligence officials signed a document saying that the laptop had all the markings of Russian disinformation, and then only to use that later on to their own benefit. Anyway, but all of
Yeah,
that
I
to
hear
say
you.
that I really, I know that these hearings are hostile. We can point out the hypocrisies in both sides with relative ease. I think, there's been a few in here, that Comer, I think Jackson, just to your credit again, Comer refuses to subpoena Lauren Mershon for her profiteering off of the Trump trial in Manhattan, over which her father presides. Clearly, there are hypocrisies to point out on both sides, but I think that ultimately, I am sick and tired, and part of the reason I called you based on a recent stream, Norm, is that I really am sick and tired of all the whiny shit. I think that
Yeah, I am too. I mean, I am.
serious people, I think serious people need to get in the game. That's what I
But
think.
how can they get in the game when it's, when there's all this blood money out there that makes the primary the victory, the primary winner the winner, and there's all this trash and hatred, online, that makes it impossible to get to the real candidate. Jim Jordan, I was so disappointed in him during the January 6th trial, there was real drama going on during that trial. There were sealed secret proceedings where defense counsel were given information in the Proud Boys case that we cannot share with the public about confidential human sources. At the very moment that Jim Jordan and his oversight committee were raising questions about CHSs, do you think one of the the fact that there were secret hearings was no secret to the press who reported on it because they were thrown out of the room? Did Jim Jordan ever pick up a phone? Did Jim Jordan ever send a subpoena? Did Jim Jordan ever make an effort to find out what was going on in a collateral branch of government?
Well,
No.
it's amazing, Norm. It's amazing. We actually went down a rabbit hole, and you in particular, I think, spent a lot of intellectual capital determining what the police power was of the Capitol Police when it comes to congressional subpoenas of private individuals.
Yeah.
And I'm talking specifically about Alex Jones, right? Way back when. And it just seems amazing that private citizens and even somebody with the status of Alex Jones has the worry and the anxiety and the fear of potentially being held in contempt, or even you as the attorney. We even went down that rabbit hole about, the assertion of attorney-client privilege in that context. It just seems like, there is nothing coming out of it except for these sort of force multipliers for news stories and media spin on the partisan divide. Again, I just reassert that there needs to be reform to the appellate process, such that the lawfare is not so easily had in this day and age. I think that's part of the problem, is that delayed justice is justice denied, right? And I also think that serious young people need to get involved locally at a small level, civically, on a
That's
committee,
right.
on your HOA, whatever it is. Put your hands on something and actually watch how you can manifest your will out in the world. It's amazing, even if it's hard.
Ask tough questions of local leaders. How do I make a better community in which to live? And pick something substantial. There's something called the Working Families Party in Connecticut that has made a mission and a goal of extending coverage for illness for employers or for employees, that they'd get guaranteed sick time. Yeah, obviously that imposes a cost on employers, and employers can have something to say about it. But ordinary people who fall ill and are concerned about a catastrophic impact on their income have a point to make, and it's a point about how to make a better life where you live. And I find those sort of discussions far more interesting these days than just about anything that comes out of Congress. When I read the report of the Garland hearing, I just thought, I'd rather watch a fictional account of trial. This has just become, as you put it, Mike, kabuki theater. It doesn't entertain anyone. As we come into the 2024 election, it doesn't edify anyone. We appear to be on the cusp of an electoral campaign that's going to be smoke and fury, signifying nothing. I think there needs to be a popular uprising in this country from ordinary people that questions what the Democrats are up to, and quite frankly, what the MAGA rhetoric is up to. Let's not try to turn back the hands of time to an era that we may not be able to recover. Let's try to build a community in which we can all live that recognizes the reality of what's going on in those communities. That, I think, is what we're trying to focus on here at Law and Legitimacy.
I want to
We
recognize
stumble at it.
Yeah, we do, but it's important that we are at least moving forward. And Chad says, I believe this is the unfortunate new norm. It's a race to the bottom, with neither side wanting to return to normal out of fear the other will take cheap shots. I actually think I'm more cynical than that, Chad. I think that the overwhelming majority of people that we have in positions of influence and power right now actually don't have an idea of what to do. And so what we're seeing right now is what people commonly resort to in terms of very hollow, shallow, emotionally based reactions to stuff, right? If one had a vision of the common good, or a vision of where to go, and there were a collective of people that could actually bring about that and were committed to the principles of our republic, we would see something completely different. Now, that's an assumption based on the fact that technology is not what it used to be, and vice versa, right? And so our access and the movie that we watch has shifted forms and shifted mediums. And I've often said that the medium is the message in our day and age. But I still do believe that there's credible evidence that most of the people who have ascended to the levers of power actually don't have any idea of what to do. And
Yeah,
that's
I think that's right.
and so
I
they're
think it's
distracted
scary.
into trying to fake it for everybody else.
I think that's scary. Well, we'll be back tomorrow morning with another exciting edition of As the World Burns. No, we are looking for hope in dark and smoky places, and we are encouraged and grateful for those of you who come back to listen every day and who make contributions to the discussions that we find useful and can advance. Mike, how do people find us?
You can find us on the red, green, or the black platform, either any of those, uh, at LawPod Daily. Law and
And
Legitimacy.
we'd appreciate your likes. We'd appreciate your contributions. We're trying to build an independent platform, and it takes work and it takes your contribution. So thanks for coming in. We'll be back tomorrow. And as always, AMF Yo Yo.
AMF Yo Yo. See you later, Norm. See you later, everybody. Thank you for being here. See you tomorrow morning.